Hello guys, and welcome to another episode of my lecture. This is Olayeni Diekolola Daniels, popularly known as Dieko Spectre, and welcome to another episode of Law of Equity. On today's episode, we will be talking about what is choices in action. Trust me, this is one of the most difficult areas of the law of equity. Not because necessarily it is so difficult, but because of how abstract it is. It is quite difficult to be able to imagine property not being something that you can hold or something that you can see transfer. And that is what choices in action is. But not to worry, during the course of this particular lecture and other subsequent lectures where I'll be talking about necessary things in relation to the assignability of choices in action, I am going to break down every single part for you to have a very fundamental understanding in relation to the topic choices in action. If this is your first time of coming to my channel, I want to say a very big welcome to you. Thank you for coming to my channel. Please make sure that you click the subscribe button and make sure that you click the notification bell so that anytime I release a video of this nature, you are going to be one of the first set of people to watch that particular video. Also, if this is the first time of coming to my channel and you are currently offering the law of equity in your university, or you want to learn more about the law of equity and the sales of lands and what have you, then I will advise you to go to the law of equity playlist, where I have pre-recorded every video necessary for the law of equity in relation to maxims. The 12 maxims, I have the lectures for each of them from maxim 1 to maxim 12. Also, I have the lecture for the doctrine of notice, from actual notice, imputed notice, and constructive notice. Also, I have the lecture to how to identify equitable interest, all the equitable interest necessary for you to identify as a university undergraduate. I have all these lectures pre-recorded on my channel. Just go to the playlist and select each of the lectures that you want to listen to. But today's lecture is the beginning of another series of lectures where we'll be talking particularly about choices in action. But before I go straight to the substance of the lecture, I would like to shout out to two particular people. The first is a student of Delta State University in Nigeria, Blessing Ernest, who made sure that the notes for these lectures are made available by typing them, and also Ojuwole Emmanuel, the person who makes sure that every graphics in relation to this lecture is made available. Thank you so much, guys, for all you do. Ojuwole Emmanuel is a University of Lagos undergraduate. Thank you so much. So now we move straight to the crux of our lecture, to the substance of our lecture, and we are talking about what is choices in action. So let's go straight to our notes, as it is our tradition. So according to the notes, property is broadly classified as reality and personality. Now, for you to understand choices in action, you need to start from what is property. Why? Because we want to go to the abstract part of property. But before we get to that abstract part, let us start with the tangible one, the one that we can see. So that is why we need to tell us what are the types of property that we have. You know what property is now? Something that you can own, right? Is your property. So you carry your phone, you can own it, is your property. You go to land, you buy it, it's your property. Anything that you can possess is your property, right? That is why it is called property, because you can possess it. Therefore, you now go to the types of property that we have. How are they classified? And they are classified as reality and personality. Okay, so now let's start with personality before we get to reality. So when we are talking about personality property, it's termed personality, can be divided into tangible and intangible. The classification is important when transfer of such property is contemplated. Now, when you are talking about personality, we have learned just now that it can be divided into words, tangible and intangible. Before, we started with what is property. Property is what? Reality and personality. Real property and personal property. That's what we call personality, reality, right? So when we are talking about personality cannot be divided into another two. We are talking about what? Tangible property, and we are talking about what? Intangible property, right? Now let us move on. Now, A tangible property can be easily physically possessed, such as table, chair, what have you. These tangible property, which are generally referred to as choses in possession. Choses, when you hear choses, imagine that you are talking about goods, so that choses, the grammar is not too much. When you hear choses, just say goods in possession. Do you understand that? Now, this tangible property, which are generally referred to as what? Choses in possession, can be stolen. So now, let us go to the second paragraph, where we said that personal property or personality can be divided into what? Tangible and intangible. Now, he said the classification is important when transfer of such property is contemplated. When you are talking about transfer of a property, that's where you begin to look at, is it tangible or is not tangible. Now, when we are talking about tangible property, we have said that things like chair, things like car, things like whatever can move from one place to the other, something that you can possess, that you can own. Are you listening? Is what? Is tangible property. And tangible property can be stolen. Also, there's something that you need to note. They can be possessed, and if intended, possession and ownership will pass by physical delivery. What does that mean? It means that I want to sell my property to somebody. Are you listening to me? Therefore, I am giving him the physical possession of a property. Let's say I want to sell my phone. I need money for something, and then I give somebody my phone. Now, giving the phone is one thing. What I'm giving to him is physical possession. However, there is something called ownership. When I want to charge my phone and I go to the shop that they are charging and I give the person my phone, I have given him the physical possession of my phone because I want him to charge it. But have I given him the ownership of my phone? No. Do you understand that? I have given him the physical possession, but I have not given him the ownership. Therefore, in relation to property, you need to know the difference between possession of something and ownership of something. That's why I said in my notes, they can be possessed, and if intended, it has to be shown that there is an intention to pass possession with ownership. If intended, then possession and ownership will pass by physical delivery. That is what? Tangible property. You want to sell your car. The fact that you have given Mr. A your car does not necessarily mean that the possession has passed with ownership. Now, you should note that you don't necessarily need to collect money from the person for possession to have passed with ownership. You can gift the person. Are you listening to me? But it is your intention to pass ownership to the person by gifting. But when you give the person to use it to do cab for 2-3 weeks, you have not given him the ownership, you have given him possession. There are two different things. When you tell him temporarily use it for this, or temporarily wash my car, or temporarily service my car, or temporarily do something with my car, you have given him the possession of the car, you have not given him ownership. Do you understand that? Now, we then go to the next part that says that intangible property cannot be physically possessed. This is the place where we are talking about choses in action. Can we see where we started? But before we get to this part, we need to talk about reality. When you hear reality, you are hearing land. Real property, you are hearing land. So that is the difference between personal property. Personal property, you are hearing goods. Real property, you are hearing land. Are you listening to me? So under personal property, you now have, tangible property and intangible property. When you're talking about tangible property, you are talking about what? Goods that can be possessed. Choses in possession. When you're talking about intangible property, that is why we are now coming to, we're now saying that intangible property cannot be physically possessed. Such property include what? Debts. Include what? Copyright. Include what? Shares to companies. Patent. Design. And they are generally called what? Choses in action, as was stated by Channel J in the case of Tokington versus MAGEE. Tokington versus MAGEE. Now, you see this Channel J. If you can, just go and read up the case of Tokington versus MAGEE. That case will give you a very good and solid perception about choses in action. It's good. You should go and read the case, what Channel J particularly said. But in this class, I will just walk you through it. Now, when you are talking about choses in action, we are saying that we cannot physically have this thing. We can't physically see this thing. We can't physically possess this thing. We can't physically own this thing. However, there are rights that though cannot be seen but can be enforced by law. Are you listening to me? Now, what are we talking about? Now, you did something. You want to record a song that you wrote yourself. You entered the studio and then you recorded that song. That song is yours, ownership, right? Now, you transfer the song to someone else. Are you listening to me? You transfer the song to someone else. That person transferred it to another person. That person has transferred it to another person. Now, all these transfers have been going. But do they have the ownership of the song? Any person that you transferred that song to, does that person have the ownership? So, for example, the song that is currently reigning now is Terminator by Ashake. I'm just using an example. Now, when you are listening to Terminator or you are listening to Bandana, you know, Ashake is the one reigning now. You know, Fireboy have reigned, and you know, to a particular extent. Naira Marley has reigned, and to a particular extent. Now that Ashake is reigning, you have Ashake's song. You possess Ashake's Terminator, but do you own the song? That's the first question you need to ask. Do you own the ownership of that song? Do you understand? Secondly, can you see Ashake carry the ownership, own it, carry it with his hand and say, yes, it's my song? Do you understand what I'm saying? Can you hold the song and say, this is my song and I have the ownership to the song? That's not possible. Do you understand? That those are what they call choices in action. There are rights that certain people would have, but you cannot see those rights, but you can enforce those rights in the court of law. Do you understand that? Another thing that you can talk about, shares in company. You carry your money, you went to a particular company, let's say First Bank or Tesla or one of these companies, and then you buy the shares. Can you see shares? Do you understand? You can't see the shares, but you've bought the shares and then you are the owner of those shares, though you cannot see it, but they are enforceable in the court of law. Do you understand that? You can't see the shares. You can't, all you can see is a piece of paper. Piece of paper is not shares. Do you understand? But that piece of paper is evidencing that you have a right to the ownership of the company, which is the shares. What you can hear is a song that was written by something, or a book that has been written by somebody. Are you listening to me? Somebody wrote a book. He has the copyright to that book. The fact that you have duplicated the book into 1 million copies does not mean anybody who possesses a copy owns the copyright. No, definitely not. What it means is that although there are 1 million copies, one person or group of people who must have co-authored the book have the right of what is called ownership to the copyright. That ownership, you cannot see it. The copyright, you cannot see it. The shares, you cannot see it. But you can enforce it in the court of law. Do you understand that? You can't see it, but you can enforce it in the court of law. And that is what Channel J said in the case of what? Tokington versus MAGEE. Now, to the next part of our notes, it tells us that a choice in action is a person's right in property which can only be enforced by taking legal proceedings and not by taking physical possession. I think I've already said that. You don't hold it. You cannot physically possess it. However, you can go to court and enforce it. You can go to court and enforce it, but you cannot physically possess it. Do you understand that? Now, it is intangible property and therefore it cannot be physically possessed. Choices in action may be either legal or equitable. Now, we have been told that choices in action may be legal or it can be equitable. Now, what's the difference between that? Legal choice in action are such rights which may be recovered by an action at common law, such as debt, copyright, bill of exchange, policy of insurance, or shares in a company. While equitable choices in action are such rights which can only be enforced by proceedings in equity, such as interest in a trust fund or legacy in a will. So you can see that. Now we are getting a step further. Okay, we know what choice is now. We are now talking about the difference between the legal choice and the equitable choice. According to what we've learned, we are being told when you are talking about legal choice in action, we are talking about what can only be enforced at common law. We are talking about bill of exchange. We are talking about copyright. We are talking about debt. We are talking about policy of insurance. We are talking about shares in a company. Those are examples of legal choices in action which can only be enforced when you go to the common law courts. In my previous videos, I've been able to explain to you the difference between the common law and the law of equity, and every single thing that happened before they were combined together by virtue of the Judicature Act of 1875. I already explained that in my last sets of video, my previous set of video. In this class, we are talking about the difference between the legal chose in action and the equitable chose. And when we are talking about equitable chose, we are talking about interest in a trust fund, or we are talking about legacy in a will. Things like that talks about equitable chose. And with that, we end our lecture for today. Thank you so much for watching to the end of the lecture. Make sure you subscribe, like, and share this video. In my next lecture, I will talk about the history of chose in action as well as the assignability of chose in action. What does assignability mean? It means when you give another person your chose. Okay, I have a copyright to a book and I want to give it to someone else. You assign the right to someone else and all that. We'll go in depth when it comes to that in the next class. Please make sure that you stay tuned. Don't forget to follow me on LinkedIn at Daniels and on Instagram at Dearco_Daniels. I will see you in my next class.